very happy to have the Attorney General for the state of New York, Eric Schneiderman, on the line with us. Attorney General Schneiderman, welcome to the program.
Thanks, Tom. Great to be here.
Thank you for joining us. And you are also, I should say, the chairperson of the President Obama's Mortgage Fraud Task Force. And you've been working with Beau Biden, who was on this program a couple of days ago, looking into what's going on with the banksters here. You just went after J.P. Morgan Chase. How did you get started tracking, going down this road that led to this J.P. Morgan Chase? Is indictment the correct word?
No, it's a complaint.
Thank you.
It's a 31-page complaint seeking that they give back everything that they took in through fraud. The way I got started was really pretty simple. When I got elected beginning of last year, took office, and at that time there was a negotiation going on between a lot of my fellow AGs and some agencies in the federal government to try and resolve issues related to abuses in the foreclosure process, really focus more on robo-signing and things like that, than on the underlying securities fraud that brought down the American economy. The banks were seeking very broad releases. They really wanted to be let off the hook for their conduct in 2004, 5, 6, and 7 that created the bubble and the crash that we're still trying to recover from. I took a very hard line that we were not going to let them off the hook. I was not going to sign on to those releases. Beau Biden was another AG who stood with me in that position. And late last year, the White House and my federal counterparts came around and said, okay, let's narrow the releases. Let's have a joint investigation. And in the State of the Union address, the president announced the creation of our working group. So I'm a co-chair of that, along with colleagues from the Justice Department, the Securities and Exchange Commission, and U.S. Attorney John Walsh from Colorado. It has been an incredible, unprecedented state-federal collaboration that's enabled us to bring this complaint, and more complaints are to follow. But this is a what's called a platform case. This is not about one deal or two deals or 10 deals. This alleges that J.P. Morgan Chase's as successor to Bear Stearns and EMC Mortgage, companies that they now own, is responsible for a pattern of really pretty flagrant fraud. Probably the only way I can describe it. The entire process of their issuing of mortgage-backed securities, in the time when the worst of the worst loans were being given out and the worst of the worst securities were being sold to investors, 2005 to 2007, was based on fraud. Bear Stearns was the number one issuer of mortgage-backed securities back then. They issued $113 billion worth of mortgage-backed securities in 2006, and all the investors who bought them were assured multiple times that they were checking the loans, that they had a good system of what's called due diligence to make sure that all of the lenders they bought from in bulk were following appropriate guidelines, that they were checking for the borrower's ability to pay, that they were examining the loans, they had third-party firms running checks, and that even after they deposited all these mortgages into the mortgage-backed securities and sold them, they continued to monitor. These are all promises that were made to the investors, and no one, in our view, was going to buy a mortgage-backed security from a firm that didn't say they were at least checking to make sure the paperwork was right, the loans were good. It was all a sham. We have internal communications showing that they were not doing anything like the due diligence process they promised. They referred to it in their promotional materials as robust and intensive. Inside, they acknowledged to each other how bad things were.
Right.
We have evidence from a third-party firm that they hired, a specialist in this area, that they hired to examine loans. And we have evidence from the third-party firm that they kept identifying bad loans, and the folks at Bear Stearns would wave them in, would say, we don't care about the problems. They put a lot of them in their securities anyway. And they identified their, in one particularly telling comment, they identified the lenders as their, quote, number one client. So they were more worried about their relationship with folks like Countrywide and American Home Mortgage, who were giving out bad loans, because they were afraid of, if they rejected too many of the loans, that they wouldn't be getting any more from these lenders.
Those
and they
people
needed
just
the
go to
loans
another bank.
keep making money on the securities. So this is the pattern of fraud that we've been investigating with the help of our colleagues in government. The SEC has been terrific about sharing their knowledge and experience and information. Folks at the Department of Justice. We had U.S. attorneys' offices all over the country helping us doing interviews and things. So this is, the president, when he announced this, really made it clear that we were going to dig in and once and for all do something about the fraud that brought down the economy. And I can say this working group is working, Tom. We brought this case, and there are more to come. It
is spectacular, the work that you're doing, Attorney General Schneiderman. We're talking with the Attorney General for the state of New York, Eric Schneiderman, whose purview, of course, includes the New York banks, which are located in New York. My understanding of the history of what allowed these banksters to do this kind of stuff has always been that in '99 and 2000, Phil Graham's wife, Wendy, was on the board of Enron. Ken Lay wanted to be able to trade oil futures and other kinds of options as securities in unregulated markets. So we got Graham Leach Bliley and the Commodity Futures Modernization Act that allowed Enron to be more like a bank, blew up the line between commercial banks and investment banks, and that also, moved or created a whole new area of securities that didn't have to be traded on regulated exchanges. Is that an accurate understanding of part of the genesis of this problem, or is something else at the root or the core or the cause of this problem?
Well, I think there are two problems, and we have to be very clear about that. And the first is what you're referring to, which is this era of really irresponsible deregulation.
Right.
And it took place across the board. It wasn't really just in the context of banking, but we do know that, as you mentioned, the Commodity Futures Modernization Act came out codifying the idea that they weren't going to regulate derivatives, but there were other things that happened. The actual amount of money that banks were required by the federal banking regulators to set aside to back up their mortgage-backed securities was reduced early in the last decade. In 2004, in a particularly horrendous piece of public policy, the federal government declined to regulate some private loans and then went on to preempt states who were trying to regulate some private.
Yeah, that was the Bush administration. Actually, didn't they executive order or go to court or something to stop the states from trying to regulate those things?
Yeah, no, this was a big controversy. But in addition to the reckless deregulation, and that's something that it's tremendously important that we get a little more public attention and a little more activist attention on the rulemaking process that's going on in Washington now, where the whole point of the Dodd-Frank rulemaking is to solve that problem, to put into place a good system of regulations to ensure this never happens again. But in addition to the bad deregulation that made some things legal that shouldn't have been legal, that wasn't even enough for some of these folks. In addition to that, we never passed a law saying it's okay to commit fraud. We never passed a law to say you can promise your investors over and over again that your securities are being checked carefully and that you're examining all the loans, very detailed representations in prospectuses and all sorts of offering materials, and have that not be true. You're not allowed to trick people into buying securities stuffed with bad loans by assuring them that you have this high-quality due diligence process,
right.
And risk scoring, and that you're checking this out. In fact, as early as the beginning of 2005, the defendants were reducing the amount of due diligence conducted, and as one of them said, in order to make us more competitive on bids with larger subprime sellers.
So these guys were breaking the law to make more profit. How did they think they'd get away with it?
It's one of those things that you see as a pattern. I've been in this business for a while. I spent 15 years in private practice. I actually represented some big financial services firms. I know a lot of folks in the business. Sometimes you see other folks doing it, and things look too good to leave alone, and you just lose your sense of things. But what is clear from the internal documents we've gotten, and we subpoenaed J.P. Morgan Chase, my office subpoenaed them last June. We've been working on this investigation since last spring. we've seen from the internal documents that there was just this relentless pressure to get more loans, produce more securities, time pressure. The folks who were supposed to be reviewing them sacrificed quality for quantity, starting in '05 through '06 into '07. And we know that's when really the most toxic securities were sold. They were bought by investors who were well-to-do, but they were also bought by pension funds, by mutual funds. A lot of folks lost their retirement savings. And when the bubble crashed, because this is what was driving up housing prices, the fact that they gave lines of credit to these unscrupulous lenders. The lenders were out there giving folks who should not have been buying a house loans. I mean, they were out, the number of loans that were either negative amortization or interest-only loans, that's to say, you're not really paying off your loan. In fact, with negative amortization loans, you owe more each month. It went from a tiny portion of the market to close to 30% of the market over this period of time.
Attorney General Schneiderman, I'm sorry we're flat out of time here, but it is. Hang on just a second.
You're listening to the Thom Hartmann Program. Visit ThomHartmann.com for audio and video archives.
The machine steps on me, sir. Attorney General Eric Schneiderman, thanks so much for being with us today.
All right, thanks a lot, Tom.
Thank you.